Hello everyone. May I welcome you to another session of Law After Lunch on behalf of my dear colleague Christian Tietje and myself. It's a true pleasure to see so many of you assembled in this room today, which is no surprise looking at the topic that we're going to find discussed today, which couldn't be more up to date, I think, than what it is. And while we're talking now, the Parliament, British Parliament, is about to publish a bill responding to Tuesday's Supreme Court decision that Parliament actually needs to be involved in Brexit. And that confirms the High Court decision of last autumn. But right now, today, while we're talking, new developments in that legal issue are taking place. And in that context, it gives me great pleasure to welcome my dear colleague from my time at Aberdeen, where, as you know, or many of you know, I taught for around 2 years in 2013-2014, and where I met Dr. Robert Taylor, University of Aberdeen. It was pretty much that when I was about to leave, Robert arrived, but we had a couple of very fruitful discussions while we were still both there, and we have continued them ever since. So when I'm in Aberdeen, we continue those discussions, and he has already advised me a lot on what is his perspective from a UK constitutional law point of view on these pressing issues regarding the likely Brexit of the UK from the European Union. Now, we have discussed how we can deal with that issue in 1 hour, which is very difficult, but what would certainly help is if I give a very short introduction, which I find very hard because Robert has already accomplished a couple of merits, which he asked me to not mention or to keep them short. But let me just say this. Robert has earned his degree, an LLB honors, from the University of Durham, which is where he also took Magister Juris and a PhD before he joined the Law School of the University of Aberdeen in autumn, I think September 2014, and where he has taught and researched on issues of UK constitutional law in particular, and I think that's also what his PhD thesis is about, and some of his current articles also on the UK constitutional law blog, the issue of conventions, which is for us as German constitutional lawyers maybe an oddity because it is difficult to classify it in our system, but it's very interesting, academically also very interesting to look at that. So today he's going to talk to us on Brexit, where are we now, and when we say now, we really mean now in that very hour. So Robert, thank you so much for joining us. It's a true pleasure to have you. You have the floor.
Thank you. No, thank you, Dirk, for that kind introduction. Thank you also for the kind invitation to speak here today on this very topical issue. I can get this to, there we go. Yes, Brexit, where are we now? I had to come up with that title a few months ago because we honestly didn't know where we were or where we were going. And indeed, as has already been said, on Tuesday the UK Supreme Court gave its judgment on the question of who had the power to trigger Article 50, which will very much be the main focus of my presentation today. In particular, looking at, as already been mentioned, conventions and that balance actually between law and politics that is very vital to the UK Constitution. Now, a brief reminder then, as we all know, there was a referendum on EU membership last year, and there was a majority, a slim majority, but a majority nevertheless, in favour of Britain exiting the European Union. Now, further to that, as some may know, the United Kingdom is made up of 4 nations, England, Scotland, Wales and Northern Ireland. If we look at this particular map and these particular percentages, we can see to an extent it is a divided United Kingdom. England and Wales voted in the majority to leave the EU, while Scotland and Northern Ireland, who are in yellow, on that map chose to remain. That has brought up its own constitutional problems, which I will touch upon later on in this presentation. Now, there are two issues really then I need to address. There are many issues that come out of Brexit. One of them, of course, is what would a post-Brexit Britain look like? How would a post-Brexit EU develop and change, and how would it address some of the problems that have arisen as a result? The legal issues I'm interested in then is firstly the Article 50 issue, which is very much the focus of the recent cases in the United Kingdom. The other one, of course, as I mentioned, is the devolutionary side, which was also part and parcel of that recent decision. So there's those two different elements. One, who has the power to trigger Article 50? And the second is, well, what about devolution? What about the constitutional arrangements in the United Kingdom for Scotland and Wales and Northern Ireland and England, especially given it was such a split vote? Now then, most of you, I imagine, are very familiar with Article 50. Very much after the referendum result, people in the United Kingdom became very familiar with it as well. Needless to say, many were expecting or predicting a victory for Remain, but it didn't turn out that way. So Article 50 became very important all of a sudden. When will Article 50 be triggered? The Prime Minister at the time, David Cameron, had of course suggested that, well, the government would just trigger it after a result came in, if it was in favour of leaving. He very quickly resigned, however, so there was a question of, well, he can't do it, the next Prime Minister must have to do it, and so there was a leadership contest in the Conservative Party and so on, and then by autumn of that year we had Theresa May. As the wording of Article 50 there says, any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. More often than not, that would be a very straightforward question. What does the Constitution tell us? Well, as many of you probably know, the UK does not have a written, codified or entrenched constitution. We didn't really know the answer to that. We weren't sure what the Constitution said. There were, in fact, conflicting views as to what it was. So the question quickly became not simply when is Article 50 to be triggered, but who triggers it. And there were very much two arguments. Who has this power? Well, the government thought they had it. They were pretty convinced that the Crown had this under the royal prerogative, which I'll explain to you very briefly in a moment. But then there was a counter-argument. The counter-argument was no. The British Parliament has it, and the British Parliament has the power. They're the ones who have to authorise the withdrawal from the European Union, because it was Parliament, essentially, that made EU law directly effective in UK law by passing an Act of Parliament called the European Communities Act 1972. This debate, interestingly enough, was ignited mostly amongst academics at the time. The parties were having their own issues in terms of who was going to take over and what was going to happen, and so very much the academic community started looking at this first before it became a real legal issue, I suppose. Brief recap then. What is the royal prerogative? Some of you may be familiar with it, you may have heard about it. Best definition, I went a bit too far there, best definition then is by Dicey, which he described as the residue of discretionary or arbitrary authority, which at any given time is legally left to the hands of the Crown. Britain has an uncodified, unwritten constitution because if you speak to sort of traditionalist scholars, it never had a revolution, it just evolved. The king used to do a lot of things, apparently. The king had to have the power to send armies out and make peace treaties or dispense justice, and essentially over the centuries, some of that powers have disappeared, some of it remains. And so the argument is the power to trigger Article 50 rests under one of these prerogative powers. This is a summary of various powers that still exist. They are not statutory, they are not found in any other written form. These are things that is left to the power of the Crown, which is often exercised by ministers. Some of them are exercised personally by Her Majesty the Queen herself. She has to give assent to a legislation. In other words, she has to rubber stamp whatever Parliament passes, and that makes it law. But there are other ones that are exercised essentially by the government ministers on her behalf, as it were. One of the major areas left is the making of treaties. This is executive authority. This rests, they say, under the prerogative. The government, the Crown, makes a treaty. It can revoke a treaty. So the idea is it rests with the Crown. It's historically proven, no need to worry. Well, then you have parliamentarian argument. Dicey there again, and I do quote Dicey an awful lot. For those unfamiliar with it, but the idea of parliamentary sovereignty essentially is legislative supremacy. Parliament has the right to make and unmake any law, whatever. It is the highest form of law under the UK Constitution. There is nothing higher than it. There is no entrenched constitution. There are no limits on its power in any traditional sense. So the argument here then is, well, Parliament's sovereign, and the UK is a dualist state. So international treaties once signed by the government do not become part of the domestic law automatically. Parliament has to incorporate it via an act of Parliament. And when it joined the European communities in the early 70s, that's what it did. It passed an act that said EU law, what would then become EU law anyway, would have direct effect and would have supremacy under the UK Constitution. What it meant by that was, if Parliament passes a piece of legislation that contradicted EU law would take primacy over that. It would disapply, essentially, the domestic law. Now, if we are to leave the EU, it was recognised early on that, well, actually, this act would have to be repealed because it made EU law essentially part of the domestic law. So Theresa May said, well, we'll have to repeal this and we will pass a Great Repeal Bill. And what this bill will do is it will come into effect essentially the day after Britain leaves, and it will take all of the EU law, all of the rights and privileges and everything associated with EU law, it will make it part of the domestic law again. But instead of being EU law, it's simply an act of Parliament. So it'll just say everything that was EU law, well, it carries on. Parliament says so, if and until Parliament decides it doesn't like certain bits or it wants to get rid of it. This was seen as a transitional exercise. We didn't want to sort of fall off the cliff in leaving. The government said, we want to make sure the rights and the laws carry on and then we can tinker with it as we want. So the argument is, if the European Communities Act, which was passed by Parliament, says we're to be a member of the EU, only they can say we're not to be a member of the EU. Now, I won't go through all of these in detail. I thought I made a nice little collage. What the case really comes down to is the relationship between the powers of the Crown, the royal prerogative, and statute law. If the prerogative says something and the statute says something, if they're on the same thing, who wins kind of thing. Now this goes back centuries. The top case there in yellow, case of proclamations, was heavily cited in the recent cases on this. So it goes back to 1610. Case law against the king. The king hath no prerogative but that which the law of the land allows him. The idea is the king cannot simply exercise any powers it likes. It has to be granted in some way or recognised by the law. We see this trend continuing over the centuries. One of the interesting ones, the Zamora case there, which was heavily cited as well, the idea that the King and Council, or indeed any branch of the executive, has the power to prescribe or alter the law to be administered by the courts. So this law in this country is out of harmony with the principle of our Constitution. No one would contend that the prerogative involves any power to prescribe or alter law. In other words, what they're saying is, after 1688, Parliament kind of took over from the King a bit. They kept the King there, but Parliament was in charge. You cannot use executive powers to change the law. Only Parliament can change the law, okay? Only they have the authority to do that. We cannot allow the King to simply arbitrarily do what they want, or any government exercising the King's power, which is essentially what happens today. So this very much became part of it. The key one there would be the De Keyser one. It is certain that if the whole ground of something which could be done by the prerogative is covered by the statute rules. In other words, if you have one statute saying that Houses of Parliament is to be painted blue, you can't use the prerogative to then say it's to be painted yellow. No, prerogative would win. And that's a silly example, but it was the simplest one I could come up with on the spot. Now, that was the debate. And we saw legal action starting last year, essentially saying Parliament must be consulted. This is the Miller case. It went to the High Court in England. Now, the legal question that the court had to address then was as follows. The sole question in this case is whether, as a matter of constitutional law of the United Kingdom, the Crown, acting through the executive government of the day, is entitled to use its prerogative powers to give notice under Article 50. It was acknowledged that should the government use its powers without any parliamentary authority or approval, the law would change. EU law would eventually cease to apply in the UK, and that was a profound change. So the question was that allowed under the Constitution? Do those powers exist? So the question was, is there a prerogative to do this? The government says it has the power. Does it? That's what the court had to decide. We saw very early on law and politics. When the case was heard, there was quite a lot of chatter in certain parts of the press that this was to derail Brexit. Why would they want Parliament to have a say? Is it to stop the UK leaving the EU, was the argument. Why should unelected judges have the final say on what happens when, of course, a majority of the British electorate had voted to leave? We can't simply ignore the wishes in a referendum of the British people. Well, there was a lot of personal criticism of the judges, but they had to make a very clear statement, which I won't read all out to you, essentially making it very clear what their role was. So this was a simple legal question, and it was essentially one of process. It's not a question of whether we should leave the EU. We're not there to decide that. It's simply who has that power, who is to decide. Is it the government or is it Parliament? We're going to look at this as a legal question. There is no issues of justiciability. And indeed, both the government in this case and Gina Miller's side were very much of the opinion that this was a particularly legal question, despite the fact it had huge political ramifications, in the sense it could essentially decide how we might leave the EU. There was no question here that this shouldn't be dealt with by the courts. The other common ground, which has come under some criticism, is that both sides felt in this case that Article 50 was irrevocable. In other words, they said once you trigger Article 50, you can't then untrigger it. The courts, in both this case and the Supreme Court decision, didn't feel the need to say whether that was true or not, because both sides agreed they weren't going to decide on that. There is a big question as to whether this is correct, of course, and the extent to which the arguments of either side could change depending on the truth of that, and it might make a bit more sense in a moment. I will leave that to other lawyers to decide whether or not Article 50 is revocable or not, but it wasn't addressed in this case. The legal arguments then broadly were as follows. The claimant then, the argument was, of course, as I've already said, Parliament passed the European Communities Act in 1972. Parliament made EU law part of the domestic law, and this included in particular EU rights. People had rights under EU law. Parliament allowed those people to have those rights as a result. The argument then is, if you trigger Article 50 and begin the process of leaving, you are, in a sense, removing people's rights. Their EU law rights will be lost. If you change that, if you take their rights away, you are robbing them, you are changing, the domestic law. And as I've already suggested, the well-established case law says you can't use executive powers to change the law. Only Parliament can change the law. So, as a result, the ECA does not say that they consent to any withdrawal. The ECA simply says EU law is to have domestic effect in the UK. We therefore assume, because it doesn't say the Crown has the power to remove those rights and leave unilaterally, that you must have to go back to Parliament to ask them if they want to leave, because they're the ones that put us in. The government, however, the Secretary of State, had a different idea. He said, no, European Communities Act 1972, yes, it brought EU law into the domestic law, but it preserved the power of the Crown in relation to international relations. It preserved its power to make and unmake treaties. That was not changed, they argued. You could only remove a prerogative power of the Crown with express words. They said they'd have to have said in the ECA 1972 the power of the Crown to enter and leave treaties in relation to the EU is no more. And they didn't. They didn't say anything like that, therefore we still have it. Their argument, therefore, is Parliament, when it joined the EU, intended the government to have the power to withdraw from the EU at any point it felt necessary to do so and change the law, change the domestic law. Parliament allowed that. The other argument was, what do you mean people are going to lose their EU rights? No, they won't. We've got the Great Repeal Bill. You know, we'll put all of their rights into domestic law anyway, so it won't be affected. If you do lose any rights as a result, and those rights he was referring to is things like freedom of movement. If you're a British citizen, you have freedom of movement in Europe. Well, it doesn't matter if we put EU law into domestic law in the UK after we leave, we're still going to lose those rights once I want to start travelling to Europe. And so you are removing people's rights. But they said, oh no, that's fine. Because it's actually, that doesn't exist in the domestic field, that's international. That's dependent upon other nations being signatories to the treaties and our own domestic law. That's okay, that we expected that. So those are the two arguments of either side in a nutshell. They were a little bit more complicated, if they wasn't complicated enough. So the High Court had to make a decision, and they essentially ruled in favour of the claimants. Parliament, they said, has to give its authorisation to any triggering of Article 50. But how did it reach this conclusion? The decision was an interesting read. It relied heavily on constitutional principles. Now I said Britain doesn't have a written constitution, so what the constitution is and what those principles are has often been open to discussion. Well, it was an interesting judgment because it laid a lot of them out quite cleanly, talked about the fact that even if the UK doesn't have a written constitution, it still has constitutional law and it's still underpinned by constitutional principles. One of those principles is a well-established one. The Crown has no power to alter the law of the land by use of prerogative powers, which is what I've already demonstrated through some of the case law. There is in fact some statute law on that as well. The Bill of Rights of 1689 was evidence of Parliament actually removing powers from the King. So they said that was a well-established constitutional tradition. And it said it evolved through this long struggle between Parliament and the Crown. For those unfamiliar with UK history, there was a bit of a civil war in the 17th century between Parliament and the Crown. Parliament chopped the head off a king, was a republic for 11 years and invited the king's son back. And it all kind of just went back to that, but with a more limited role of the Crown. So the idea was this case that we're talking about in 2016 and 2017 actually goes back to the 17th century. And we're dealing with this very simple issue of the Crown, executive powers versus Parliament, the legislature. And the argument there was that to assert parliamentary sovereignty and constrain the Crown's prerogative powers was central to that principle. It would be surprising indeed if, in light of that tradition, Parliament, as a sovereign body under our Constitution, intended to leave the continued existence of all rights it introduced into domestic law by the ECA 1972, subject to the choice of the Crown in the exercise of its prerogative. In other words, they're saying, well look, we've had centuries of this struggle to assert parliamentary supremacy. Parliament has the right to make or unmake any law, whatever. It's the highest authority. It's unlikely they're going to say, oh yeah, but the Crown can just, allow us to leave the EU and therefore completely change the domestic law. They weren't convinced on that matter. Another issue they picked up upon was, well, what is this European Communities Act 1972? And they said, well, it's a constitutional statute, they said. I've already said Parliament's sovereign. The idea is no act of Parliament should be better than any other. So you can't entrench, you can't protect laws against easy amendment by Parliament. But they suggested here that actually the ECA 1972 was of particular constitutional significance and was immune to implied repeal. In other words, if you were to pass one act that said we're to be a member of the EU and then you pass another act that sort of suggests that we might not be, but doesn't expressly say it's to override it, then it remains as good law. And what they were saying is that basically you can't repeal the ECA impliedly. You have to use express words. We wish to repeal the ECA 1972 to get rid of it. He says now, if Parliament has a restriction on what it can do with the ECA, why could the government simply get rid of it, or at least of the rights that it embodied that easily? It would be inconsistent with the Constitution again. Their conclusion then was, because Parliament had legislated on it, there was no prerogative power to do this. You couldn't undo EU law by an act of the executive alone. You had to have Parliament involved. Now, there is, of course, if you're a constitutional scholar, the implication of this decision is that if the Crown can't alter the domestic law, it can't change an act of Parliament. The only thing that can is another act of Parliament. But the court wasn't very clear on that, and in fact, as soon as the decision came out, the government was suggesting maybe we could just get a resolution of the House of Commons and that would be enough. That will come up in the Supreme Court case. The one last thing on this case I'd like to mention is the Referendum Act. A key argument that the government had was, of course, well, look, we passed an Act of Parliament in 2015 to give the people of Britain a decision on whether or not to be a member of the EU. We can't ignore that. Surely that has some legal significance. Surely we have to follow whatever the will of the people is on that, and everyone expected the Crown to have the power to do this. So what's the significance of this referendum? It's fair to say that referendums, certainly of a UK-wide nature, are a rarity in the UK. This was only the third nationwide referendum we ever had. And the court was very clear to say that, well, look, it's passed in an Act of Parliament, we have to interpret it. Does it tell us what will happen after the referendum result? No. Therefore, it's advisory. Its legal status is it's advisory. The result of the referendum, therefore, is not legally binding on Parliament. Parliament clearly, by not saying what was to happen after the result, wanted the discretion to decide for itself. So the arguments as to the importance of that Referendum Act were pretty straightforward as far as the court was concerned. There was no language used in the Act to suggest it had any legally binding nature. That decision was appealed by the government. In fact, before that court case came about, everyone knew that whoever lost would appeal it to the UK Supreme Court anyway. So it was a bit of an interesting judgment, but we knew that the final decision would come much later. And indeed, it came on Tuesday. And the same arguments, albeit modified, came up. There was 11 justices of the Supreme Court hearing the case, and that's the largest we've ever had. It was a majority of 8 who said Parliament must be consulted to trigger Article 50. In fact, they go a bit further than that. They said that an Act of Parliament was required in order for Article 50 to be triggered, and three of the justices dissented. Now, the legal question, I'm putting this up, and my apologies, it's a work in progress. I had to read it it's about a 97-page judgment on Tuesday, and I was travelling all of yesterday, so Now, the first thing to note is then, the legal question that the courts put it as in the High Court one was, is there a prerogative power? Does the Crown have a power to essentially trigger Article 50? The question was posed a bit differently. The question before this court, they said, concerns the steps which are required as a matter of UK domestic law, before the process of leaving the EU can be initiated. The particular issue is whether a formal notice of withdrawal can lawfully be given by ministers without prior legislation passed in both Houses of Parliament and assented to by Her Majesty the Queen. So they mentioned the fact it's about legislation. Do you need prior legislation? They're clarifying the question. This is about, do you need an Act of Parliament to authorise it? It's less concerned with, does the power kind of exist? Shall we look at all of the various different cases decided over the centuries? So more focused, arguably more to the point. And emphasising yet again an Act of Parliament that both houses have to pass, not simply the House of Commons passes a motion, but that you would also need the consent of the unelected House of Peers or House of Lords. Yet again, law and politics came up because they knew that there was a lot of public interest in this, and there was a sense among certain Brexit MPs in particular, pro-leave MPs, that this would subvert the democratic process, that if you allow Parliament a say, this is subverting the will of the people. You're giving Parliament the opportunity, or parties within Parliament, the opportunity to derail Brexit, or make it a soft Brexit, or do whatever it is they didn't feel was appropriate. Yet again, they emphasise quite strongly in the third paragraph, very early on, that this is a judicial matter for the court to decide. We are not deciding any future relationship between the EU. It's a matter for ministers. It's a political matter. That's not for us. We are simply there to look at the facts and say, who has the power as a matter of procedure? And that theme runs throughout. Now, Supreme Court's decision then on the issue of a constitutional statute, I put this up because one of the arguments, as I already said in the High Court one, was this is a constitutional law. It's sort of special. It can't be repealed impliedly, therefore it would be silly if the Crown could could simply make it or render it pointless through executive powers. They didn't really address that issue. I can't spend too much time on it, but that's another interesting controversial matter of UK constitutional law, whether or not you can partially entrench legislation. They acknowledge its constitutional character, is all they said, and then simply explain that yes, the ECA did give priority to EU law when it conflicted with domestic law, but that Parliament is still sovereign, and it doesn't have to comply with EU law, the UK, in relation to deciding how we are to implement EU law. In other words, whether or not we pass an act of Parliament or we repeal it or whatever. That's beyond any concern. So they didn't really engage with that slightly more academic question. One of the major arguments which was clarified in this case was on the government side. I already told you that they suggested that Parliament, through the ECA, essentially in 1972, preserved the power of the Crown to unilaterally trigger Article 50 and leave. One of the arguments as to why they would be allowed to do this, despite the fact it would affect domestic law, people would lose their EU law rights, is that the ECA acts as what he calls a conduit. This is the international law, domestic law field again. The idea is Parliament passes an act. It says all of EU law, which is in the international plane, travels through this conduit and comes into the UK domestic law. The government, in triggering Article 50, is just closing that conduit off, so all those EU law rights can't come through it anymore. That's all the ECA did. It wasn't making EU law domestic law. It was simply giving it effect, and those are international rights and laws that are being given domestic effect. The Crown, as they said before, reserves the power under this Act to simply trigger Article 50 and stop those international law rights from flowing through the conduit into domestic law. The other key thing was, of course, well, EU law changes all the time. It varies a lot. The content of EU law varies. That's evidence, really, of its international law character being put into the domestic field. Therefore, Britain withdrawn is no different. You know, one day we have varying EU law rights, one day we have no EU law. No difference. The court wasn't convinced. They agreed, paragraph 76, that yes, EU law varies. The United Kingdom's obligation from time to time under the treaties will vary. However, they reiterated the fact in paragraph 77, we consider that by the 1972 Act, Parliament endorsed and gave effect to the UK's membership of what is now the European Union in a way that is inconsistent with the future exercise by ministers of any prerogative power. Key thing is, if I can find the right quote, there is a vital difference between changes in domestic law resulting from variations in the content of EU law, arising from new treaties or legislation, and changes in domestic law resulting from the withdrawal of the Kingdom and through the EU. One, it says, involves a change in EU law, which is brought through via domestic law, the 1972 Act. The other one is a unilateral action by a constitutional body which changes and affects the fundamental nature of the law. So they're saying, we know it varies. The ECA said EU law varies. But stopping that law entirely, unilaterally, without anyone else's consent, is simply inconsistent with constitutional law in the UK. There is a fundamental difference between it changing and you eliminating a source of law. But because the UK Constitution is unwritten, you have to find the rules in different places. And you are removing one whole source. I always tell my students, here are the sources of the law of the Constitution. One of them is EU law. That would just disappear. That's a fundamental change. The bigger question, I know I'm probably running a bit late as well, is, well, this is about triggering Article 50. In other words, the UK says we're going to leave. We begin the process of leaving. As soon as they trigger Article 50, we're not gone yet. Might take 2 years, might take a bit longer. So the argument is, why is triggering it now affecting the law? If you trigger it tomorrow, the law isn't going to change that day or the day after. You'll still have EU law up until we go. So how is it affecting domestic law? Well, the argument tried to counter this. The government, tried to counter-argue this. They said, well, it's not going to go. We're going to have the Great Repeal Bill. It's going to stay there, just in a different form. Now, the High Court wasn't convinced. because they said you can replicate some of them but not all of them, like freedom of movement for British citizens in Europe. So they had to address this question as why would this be a problem now? The first thing they say is, well, it's a Great Repeal Bill. What is that? That's a promise by ministers that they're going to pass a law in the future. It's not law yet, and the courts only enforce the law, not promises as to what the law will be, and that's established case law. And the way they put it is that it seems very likely indeed, but it misses the point, he says. If ministers give notice without Parliament having first authorised them to do so, the die, they say, will be cast before Parliament has become fully involved. To adapt Lord Panick's metaphor, the bullets will have left the gun before Parliament has accorded the necessary leave for the trigger to be pulled. This very fact that Parliament will have to pass legislation once the notice is served and hit the target highlights the point that giving of the notice will change the domestic law. So what they're saying is, Parliament has to have a say. You're saying Parliament will. You're saying once we've triggered Article 50, 2 years down the line, they're going to have to repeal the ECA and pass the Great Repeal Bill. So you're saying Parliament has to be involved. But if you trigger Article 50 now, you're essentially sort of preventing them, well, the criticism would be you're preventing them from changing their mind, because once you triggered it's irrevocable, therefore Parliament's not involved in that decision. But that if you trigger it, it will eventually change the law. So if you're saying that they have to change the law 2 years down the line, they might as well get involved now to agree to the fact it might have to change 2 years down the line. It was a flaw in the government's argument. The argument was that if you admit that Parliament has to repeal the ECA in the future, why do you say they can't be involved now when clearly they're going to have to be the ones who are involved in that process from day one? So they're essentially saying that triggering it now would affect the domestic law at some point down the future, and that wasn't in any way detrimental to the argument. And as I say, what they reiterated was that you had to have an act of Parliament. There was a lot of speculation beforehand as to whether or not you needed legislation. And the argument was, well, of course you do. You can't get away with, a resolution of the House of Commons is not better than an act of Parliament, therefore you have to have an act of Parliament. And they made that very clear. Primary legislation required. Now, they ruled also on the Referendum Act. Just I won't spend too long on this. They came to the same conclusion, essentially. They acknowledged the fact, guess what, referendums are kind of a new thing, so we're not entirely sure how they fit into the legal framework, but we do know that an Act of Parliament passes it, and an Act of Parliament will tell us what the referendum's legal effect will be, and it didn't tell us. The referendum that the UK held in the 1970s to join the European Community also didn't say what was to happen, therefore it didn't change the law. But the key quote is at the bottom, law and politics. The referendum of 2016 did not change the law in a way which would allow ministers to withdraw from the UK from the EU, because the argument was, we've been given the instructions by the UK people, therefore we can go. They said, no, the legal power wasn't given to you. But this in no way means that it is devoid of effect. It means that unless and until acted on by Parliament, its force is political rather than legal. It has already shown itself to be of great political significance. So what they're saying is legally, we can't enforce any result. Legally, it doesn't give ministers power to do anything, but politically, maybe it can't be ignored. Politically, it has some kind of significance. And what they're saying is it's not really got anything to do with us. It has a political force. The whole reason why we have the cases there is because of this referendum. So it has a political merit, but not a legal one. Now, coming towards the back end of the presentation then, that was what the Supreme Court said in a nutshell. I apologise if I've been going too fast trying to cover it. Parliament must be involved in triggering Article 50. It must pass a piece of primary legislation. The House of Commons, the House of Lords, and the Queen must essentially agree to this piece of legislation. They also touched upon the issue of devolution. As I've already said, a bit of a divided United Kingdom following the result. Now, there was another case. The Supreme Court was also dealing with an appeal from the Northern Irish courts about the nature of the Northern Irish devolution. That allowed as well Scottish Government to get involved in the decision. the big question that's really hanging over this whole thing is, yes, there's the issue of Brexit. What would a post-Brexit Britain look like? But will the United Kingdom actually survive as a United Kingdom? Or are we going to see a second independence referendum in Scotland? Because the majority of Scotland voted to stay, a majority in England voted to leave, and Wales and Northern Ireland as well are involved in that. Now, Nicola Sturgeon there, First Minister of Scotland, very recently set out her key Brexit plans. Not pushing for an independence referendum, she said. What we're going to do is we're going to influence the UK negotiations. We want access to the single market. If the UK government does not want to have access to the single market, we're going to ask that they give a special place to Scotland, and maybe we can have access to the single market. And then maybe if we can't do any of them, we have to then look at independence. Not long after that, Theresa May said in a public speech that she wouldn't look for access to the single market. This essentially torpedoed, to an extent, Nicola Sturgeon's key negotiation strategy here. And she's under pressure now to have an independence referendum again. We don't know yet if or when Scotland will have one. Nicola Sturgeon is still trying to work with the other devolved institutions and the UK government to come up with an amicable solution. But it's certainly caused political difficulties. Now, that's the setting. Scotland wants to stay in the EU. If not, it wants to have access at least to the single market. Dirk already mentioned conventions. Now, the UK is not a federal state. It has what we call devolution. In other words, Parliament gives some powers to the nations for them to essentially deal with their own matters in their own way on certain issues. It will then reserve powers to itself. Essentially what happens is Scotland may have powers under its own parliament and government to pass laws with regards to their criminal law, with regards to health service, things like that. They can't legislate on matters that are reserved to Parliament, in other words, foreign affairs, defence, things like that. The trick is Parliament gives these powers, but it can also theoretically take them away. And even though it says, for instance, Scotland is allowed to legislate on certain matters, actually we could also legislate on them as well if we wanted to. And ours would be the overriding piece of legislation because we're the Westminster Parliament. This was seen as unacceptable, so when devolution happened, a political rule was created called the Sewell Convention. If the UK Parliament is ever to legislate on Scottish matters, it would ask their consent first, and it would do that. In fact, we see this practice then emerging amongst the other devolved assemblies. We're not going to be the all-powerful Parliament. If we will ask, or if you ask us, we will consent, and so on. This political rule is not legally enforceable, okay? But it was recorded in statute recently. Acknowledged as a convention, the rule is, but it is recognised that Parliament of the United Kingdom will not normally legislate with regards to devolved matters without the consent of the Scottish Parliament. It's preserving a bit of discretion there for Westminster to decide what normal means. But the point is, when this case came up, the Scottish Government was quite keen to stress the fact, well look, we have to be consulted on Brexit. 62% of the Scottish people voted to stay. Parliament cannot simply pass an act of Parliament to take us out of the EU without our consent. These arguments were put before the court. The first thing they had to decide, because there was an appeal from Northern Ireland they had to decide before they got onto the Sewell Convention. But even though there was a split of 8-3 on the question of Article 50, they were unanimous on their understanding of the devolutionary issue. It was not a legal requirement to consult the devolved institutions of the United Kingdom on this issue. The devolved legislators, they say, do not have a parallel legislative competence in relation to the withdrawal from the European Union. It is a reserved matter for Westminster. You are not involved in this process at all. They did say, of course, that yes, if we leave the EU, that will affect your competences, your powers as a devolved assembly. But that comes down to the Sewell Convention. And they said that it was, yet again, it's a convention, it's a political rule, we can't enforce it. It is incapable of legal enforcement. Despite this, they tried to emphasise the importance of conventions. In reaching this conclusion, we do not underestimate the importance of constitutional conventions, some of which play a fundamental role in the operation of our constitution. The Sewell Convention has an important role, but the policing of that scope and the manner is the operation does not lie within the constitutional remit of the courts, the judiciary. What they're saying is this is an important rule. Whether you get consulted or not is important, but that's political, that's not legal, we can't touch it, we can't go near it. That is for Westminster, for them to decide whether or not they're going to ask you for consent. Because now there's an Act of Parliament that has to go before Parliament. The argument is, well, if you follow political practice, surely Scotland should be consulted on this, and if they don't give their consent, what are you going to do? Is the Westminster Parliament going to ignore them? Is the Westminster Parliament going to say it doesn't need to ask their consent because it's only normally, and Brexit is an extraordinary situation? These are unknown questions. These are political questions. So that's a lot of things in a nutshell. Again, what next? Well, yesterday, Theresa May announced at Prime Minister's Questions that they would publish their Brexit plans in a white paper. They're going to spell out their plans for Brexit in an official policy document for scrutiny by Parliament, because now Parliament is involved. Theresa May wants to trigger Article 50 by the end of March. Well, now she has to get it through Parliament. So she said that she would publish these plans. She didn't want to initially, but there was a lot of political pressure within her own party as well as others that she do this, so she says she will. And David Davis today is saying that it will come very soon. We don't know when, but very soon. Today, the UK government published, just before I came into this room, their planned bill for triggering Article 50, which is called the European Union Notification of Withdrawal Bill, or at least it was when I last saw it. It could have changed. I did manage to find it. It's just essentially one clause saying that an Act of Parliament that puts the government, the phrasing is brilliant, but this is very much hot off the press, is under a duty to trigger Article 50 by the end of March. So Parliament has to approve the wording of they are under a duty to trigger Article 50 by March 31st. And so that is the right. I don't know how familiar you are with legislative processes. In the UK, you have about 3 readings of a bill, and normally a bill is going to take quite some time to pass. They are trying to push this through very quickly. The first reading is today. It came out an hour ago. Basically within 2 weeks they want the House of Commons to approve it. I think it's by about the 8th of February, I believe, is the third reading, if I remember what I just saw. So this is happening very quickly. The court on Tuesday says an Act of Parliament's needed. We have the published bill. There are some problems, however, that the government faces. They expect it to be passed within 2 weeks, but the opposition parties are already saying that they want to amend this bill, because not all of them are happy with the idea of either Brexit happening or what they call a hard Brexit happening, so this idea of leaving the single market. The Scottish National Party has already said that they're going to table up to 50 amendments to this essentially one-clause bill. The second clause simply says it's to be known as the whatever act, so there's nothing else in that. Labour, which is the official opposition party, is a bit mixed on it. Jeremy Corbyn has said that he will tell his MPs to vote for it, but there's already talk of a rebellion there, and a few of the MPs suggesting that they want to have amendments to this bill as well. We don't want hard Brexit, we want a soft one at least. The Liberal Democrats, who only have 8 MPs, I think it is, if I remember correctly, in the House of Commons, they were part of a coalition with the ruling party not so long ago, the main party, the Conservatives. They want another referendum, because Theresa May a couple of weeks ago said any deal we come up with, we will put it to Parliament. She didn't say how, she didn't say if it was going to be an Act of Parliament or a motion or anything like that, but we would. So they say, well, we should have a referendum. If Britain's not happy with it, why should we leave the EU? The deal's not good enough. So they're going to try and do that. We don't know what's going to happen. Anything could happen. Even if it gets through the House of Commons within 2 weeks, it has to go to the House of Lords. And the House of Lords, an example is Liberal Democrats have about 8 MPs, but they have, I think, over 100 peers. So there's going to be a different type of opposition potentially there. Not necessarily to stop Brexit, however, simply to make sure a consensus is built on what they want Brexit to look like, and not just what Theresa May outlined in her speech a couple of weeks ago. So that's essentially where we are at the moment. That's just some of my end notes. Thank you for listening. Happy to answer any questions. Sorry for the rush.